The ambit of Article 31A was repelled by this court in Fuiboy Assistant Collector, Thana, 1965, SCR 636. There is no cogent ground to take a different view. Matthew Ifyar. The Constitution 24th, 25th, and 29th Amendments are valid p.56, 857. The Dekjion. In the Golaknath Ca1e that Parliament has no power to amend fundamental rights in such a way as to take away or abridge them wrong. The power to amend under Article 368 as it stood before the 24th Amendment was plenary in character and extended to all provisions of the Constitution. The 24th Amendment did not add anything to the content of Article 368 as it stood before the amendment. The amendment is declaratory in character, except as regards the compulsory nature of the assent of the President to a bill for amendment. Under the article as amended, all T81 provision of the Constitution can be amended by way of addition, variolon, or repeal. The only limit on it that the Constitution cannot be repealed or abrogated in the exercise of the power of amendment without substituting mechanism by which the state is constituted and mechanised. That limitation flowed from the language of the article itself, RP 857. Although the word amendment has a variety of meanings, we have to ascribe to it in the article a meaning which is appropriate to the function to be played by it in an instrument apparently intended to endure for ages the Rome and to meet the various crises to which the body politic will be subject. The nature of that instrument demands awareness of certain presupposition. The Constitution has no doubt its roots in the past, but was designed primarily for the unknown future. No existing Constitution has reached its final form and shape and become, as it were, a fixed thing incapable of further growth. In interpreting a Constitution, the court should avoid a narrow and PCNDA-NBC approach. Everything turns upon the spirit in which a judge approaches the question before him. The words he must construe are, generally speaking, mere vessels in which he can pour nearly anything he will. Seeing therefore that it is a Constitution that we are expounding, and that the Constitution Mackin had before them several constitutions, where the word amendment, alteration is used to denote plenary power to change the fundamentals of the Constitution, the word amendment cannot be given a narrow meaning. But being a familiar C.XPR it was used in its familiar J.C. Gall sense. The power to amend under that article included the power to add any provision to the Constitution, to alter any provision, substitute any other provision in its plow, and delete any other provision. But when the article said that on the T-bill, for the amendment of the Constitution receiving the President's assent, the Constitution shall stand, amended, it seems to be fairly clear that a simple repeat 81 or abrogation of the Constitution, without substituting anything in the place of the repealed Constitution, would be beyond the scope of the amending power. For it, a Constitution were simply repealed, it would not stand amended. pp. 766 to 769. Kesavananda of Kerala, Khanna, J. 9 Sankari Prasad, The Union of India, 1952. SCR 89 Sayan Singh, The State of Rajasthan, 1965. ISCR 93L Golaknath Viraswar, State of Punjab, 1967. 2 SCR 762 Rhode Island v. Palmer, 253 U.S. 360 State, at the prosecution of Jeremiah Ryan and others. Frubain. Captain Mixel Lannon and others, 1935. Irish Reports 170. Read the Central Provinces and Berar Sales of Motor Spirit and Lubricants Taxation, Act 1938, etc., 1939. FCR 18. The Queen v. Bureau, 1878, 3 AC.
889, 904-905, Attorney General for Ontario v.
Attorney 7 General for Canada, 1912. AC 571 at 583 referred to. In a rigid constitution, there is a limitation upon the power of the legislature by something outside itself. There is a greater law than the law of DIT, ordinary legislature, and that the law of the Constitution, which is of superior obligation and known to a flexible constitution. If a special procedure is prescribed by the Constitution for amending it, different from the procedure for passing the ordinary law, then the Constitution is rigid, Sir, arty. The 368 as it stood before the 24th Amendment contained not only the procedure, but also the substantive power of amendment, as the article laid down a procedure different from the procedure for passing ordinary law. Our Constitution is a rigid one, and the power to amend a constituent power. The vital distinction between constitutional law and ordinary law, in a rigid constitution, lies in the criterion of the validity of the ordinary law. An ordinary law, when questioned, must be justified by reference to the higher law embodied in the Constitution. But in the case of a Constitution, its validity is, generally speaking, inherent and lies within itself. Once it is realized that a Constitution differs from law in that A,